You've seen the courtroom dramas. A witness takes the stand, places a hand on a heavy, dusty book, and swears an oath. In real Indian courtrooms, that doesn't happen. Witnesses swear by their conscience to tell the truth. But let's look past the theater of the courtroom to the actual mechanics of justice. If the government crosses a line, say detaining you without cause, how exactly do you fight back? What specific legal lever do you pull? You pull Article 32. Dr. B.R. Ambedkar described this provision as the very heart and soul of the Indian Constitution. This article grants every citizen direct access to the Supreme Court to seek 5 specific writs, which are formal, written commands issued by the judiciary. Article 32 turns the Constitution into a live wire, providing the precise legal machinery needed to neutralize state tyranny the moment it occurs. It's easy to assume these tools were crafted by revolutionaries looking to protect the common person. But their history tells a different story. To find their origin, we look back to medieval England. Early monarchs needed a way to consolidate authority and keep feudal lords in check. They created prerogative writs. These were exclusive legal instruments, available solely to the crown, used to crush any encroachment on royal privileges. There is a deep irony here. A legal mechanism engineered to enforce absolute, unchecked monarchical control became the very foundation for dismantling it. As the British Empire expanded, they brought these prerogative writs into the colonial legal system in India, keeping that supreme power safely out of the hands of the general public. That dynamic ended in 1950. The framers of the independent Indian Republic took that exclusive royal privilege and stripped it from the executive branch. They handed the authority to issue these writs directly to the Supreme Court under Article 2. They went a step further with Article 226, empowering high courts to issue these same commands not just to protect fundamental rights, but to resolve broader legal disputes as well. This transition completely inverted the original function of the writs. A system designed for crown control over subjects had become a protocol for citizens to control the state. To understand how this arsenal works, you can use a simple memory trick, CPM-HQ. Each letter stands for one of the 5 distinct pillars of protection. Let's start with C and P. Certiorari and prohibition are twin tools. If a lower court steps outside its legal jurisdiction, a higher court uses these writs to step in, either to halt the ongoing proceedings entirely or to squash a flawed ruling. Next is M for mandamus. It translates to "we command." If a public official or government body refuses to do their required job, mandamus is the judicial order that forces them to get back to work. Q stands for quo warranto, asking, by what authority? This stops individuals from illegally occupying public offices they have no right to hold. Together, these 4 commands form a tight grid of accountability. They ensure that judges, bureaucrats, and politicians stay exactly within their designated legal lanes. That leaves the H in our headquarters, habeas corpus. In Latin, it translates to have the body of. In 1975, the ADM Jubbalpur case put this specific writ to a severe stress test during the national emergency. Political opponents were rounded up. People vanished into police custody without explanation or trial. In a devastating ruling, the Supreme Court declared that during the emergency, even the right to life and liberty could be legally suspended. The judiciary later corrected course. In cases like Sunil Batra, the court expanded habeas corpus. It became a shield to protect existing prisoners from torture, discrimination, and state abuse behind bars. The court pushed even further in the Sheila Barse case. Realizing a person locked in a cell can't always file legal paperwork, the judges scrapped the rigid rule of locus standi. This allowed activists and concerned citizens to file the writ on behalf of the voiceless. Habeas corpus operates as the absolute, non-negotiable baseline defense that secures a citizen's physical right to exist from arbitrary state violence. From the iron grip of medieval English monarchs to the democratic foundation of the modern Indian Republic, these legal commands have traveled a massive historical distance. These mechanisms exist today as non-negotiable legal rights, hard-coded into the supreme law of the land. Without Article 32 and these 5 active writs enforcing it, every other fundamental right in the Constitution would be nothing more than ink printed on paper. So next time you think about your rights, remember the CPMHQ: certiorari, prohibition, mandamus, habeas corpus, and quo warranto. Which of these 5 commands do you think is the most vital for keeping a modern democracy running? Drop your thoughts in the comments below. If you want to keep exploring the history and mechanics of constitutional law, hit the subscribe button. Thanks for watching.